Hello and welcome to our 7th episode of Privacy Unpacked. I'm Matt Buckwell and I'm joined today by Laura Goold. Today we're diving into a recent enforcement decision from the Information Commissioner's Office, or ICO, a £14 million penalty issued to Capita plc and Capita Pension Solutions Limited, or CPSL. This case is significant not just because of the size of the fine, but because of what it tells us about cybersecurity expectations, data protection responsibilities, and the consequences of failing to act on known risks. Here, over 6.6 million individuals were affected by this breach, and the ICO's findings are a wake-up call for any organisation handling sensitive personal data.
Thanks, Matt. That's quite interesting to hear how many people were affected. So you mentioned two Capita entities. Can you explain who they are?
Yeah, Capita is a well-known outsourcing and professional services firm. Capita plc is the parent company of a number of other entities, many of which are data controllers and data processors, and this is important to the fine as Capita was acting as both a controller and a data processor here.
And so for our listeners, could you explain where the ICO gets the power to fine from?
So the ICO issued the penalty under Section 155 of the Data Protection Act 2018, and in this case it was citing infringements of Article 51F, 32.1 and 32.2 of the UK GDPR. Capita plc was fined 8 million as a data controller, and CPSL was fined 6 million as a data processor, with a total of 14 million combined. The ICO applied its finding guidance, considering the seriousness of the breach, the need for deterrence, and the proportionality of the penalty, which we'll come on to a little bit more later on.
Thanks, Matt. I think it'd be helpful to look at the background. So can you run us through how the ICO arrived at the need to fine Capita?
So on the face of it, this looks like a fine for being a recipient of a cyber attack, where over 6.5 million individuals' personal data was exfiltrated from both Capita companies. However, the story really begins before that in the systems and processes that Capita put in place to protect its data. So the ICO found that Capita had failed to implement appropriate technical and organisational measures under the UK GDPR to prevent both privilege escalation and unauthorised lateral movement through the network, and to effectively respond to security alerts when detected. Penetration tests conducted in August 2022 had already flagged these issues, but Capita didn't act on these penetration tests.
Interesting. It affected quite a lot of people. Do we know how the breach unfolded and how these failings impacted it?
What we know is a threat actor gained initial access to the Capita network following the download of a malicious JavaScript file by an employee. It's unknown precisely how, but it's assumed it was a drive-by attack that doesn't necessarily need the victim to have done something or clicked on something to initiate the download. After that, the threat actor downloaded software onto Capita's systems and was able to obtain administrative privileges. This software was actually quarantined by Capita, but with this access, the threat actor was able to further explore the network, which is known as lateral movement, and discover potential areas where harm or damage could be inflicted and personal data could be exfiltrated.
It sounds like the threat actor got quite lucky in what they could access. In their investigation and the notice, did the ICO identify any specific failings in Capita's security measures and policies that led to this, or perhaps granted the threat actor extra access to data?
Yeah, so it was noticed that Capita had a number of security failings, including privileged access management, which was not utilized, allowing the threat actor to obtain domain administrator privileges. It's also more likely than not that the threat actor exploited Capita's Active Directory using traces of hashed account passwords and either impersonating that account or cracking the hash to obtain the account password. This would allow the threat actor to simply log on as that account and laterally move through the network as a privileged account holder. And then there's Active Directory tiering, which is a control that restricts administrative accounts to only the specific privileges necessary for their roles. Capita had not implemented this, enabling the threat actor to exploit additional permissions and privilege once they gain access to administrator accounts. It's important here to note that 3 prior pen tests had identified these vulnerabilities, and Capita's own internal standards required pen test reports to be sent to the CISO to analyze and record found vulnerabilities and to define remediation activities and track the progression. However, here no steps appear to have been taken to resolve these vulnerabilities. Capita had not tested the systems where personal data was exfiltrated, including those containing special category data, as these systems did not meet Capita's internal criteria for pen testing. The ICO considered this failure to not include the types of personal data being processed in the criteria for pen testing as a failure of Capita's GDPR security obligations.
Thanks for going through that. Quite interesting to hear about the criteria for pen testing that Capita used. So after the breach, did Capita do anything to fix those issues?
Yeah, post-incident, Capita took a number of remediation measures, including implementing Active Directory tiering and a more robust asset management system, and doubling the number of SOC analysts to better enable them to manage and respond to security alerts in a timely manner in the future. So now we've gone through what's happened and the ICO findings. I'll ask you, Laura, how did we end up with a penalty of 14 million across the two Capita entities?
So as a starting point, I'm going to set out the maximum potential penalties, which were 17.5 million or 4% worldwide turnover for the infringement of Article 5, and 8.7 million or 2% worldwide turnover for the Article 32 infringements. Now, the processing activities were linked, so the maximum fine available was that of the more serious infringement, so the 17.5 million or 4% turnover. The ICO considered that Capita met the threshold to apply a turnover-based calculation given their hefty profit for the preceding financial year. That's a 4% maximum. Then, considering the nature, gravity, and duration of the infringements you outlined earlier, as well as the categories of personal data, including the special category data, and then the negligence by Capita in how they'd implemented their security measures and policies, the ICO considered it to be a high degree of seriousness here. They then considered the significant shortcomings, as they put it, in Capita plc security measures, as well as the harm and potential harm to the individuals. So thinking about embarrassment, distress, those kinds of things. And again, the negligence of Capita plc. So they reached a starting point of 40% of the legal maximum fine, or £38.7 million for Capita plc. And then following a similar analysis for CPSL, the ICO considered that they should apply 65% of the legal maximum here due to the higher number of impacted data subjects where it was a processor. So that resulted in a starting maximum of £31.5 million just for CPSL. So both quite hefty figures. Then, following the fining guidance, the ICO considers different aggravating and mitigating factors. So starting with the controller, Capita plc, initially a 10% reduction was offered due to the steps they had taken to mitigate that you outlined earlier for us. And then after receiving the representations in which Capita made a frank admission of liability, the ICO increased that reduction to 20%, but noted that had Capita made that admission of liability earlier, prior to them issuing a notice of intent to fine, that reduction would have been higher. And that's to indicate the cost savings of not having to proceed with this enforcement and having reached a conclusion sooner. So that was the mitigating factors. On the aggravating factors, they considered there was a higher degree of responsibility and that Capita's appropriate technical and organisational measures had a far-reaching impact on the other entities in the group, given that they were applied at a group level. Combined with the potential damage and distress caused to data subjects, that necessitated a 5% increase in the penalty, so we come out at £33 million for Capita plc, the controller. For CPSL, the processor is very similar, but in that case, only mitigating factors were applied, no aggravating factors were applied. So the adjusted penalty is 25 million there, giving us a total of £58 million.
Wow, that is indeed a large fine. So how did we get from there to the 40 million in total that we ended up with?
To get there, the ICO then considered whether the proposed amount would be an effective and deterrent measure against future non-compliance. And that's not just non-compliance by Capita, but also other organisations. So whether this sends a message across the sector and across data protection in the UK. The ICO considered it was. However, the ICO did not consider the amount to be proportionate, as the infringements were intrinsically linked, and so it would have been disproportionate to impose fines at that level on both entities. The ICO also looked at the financial impact on Capita as a group and the recent falls in revenue it had experienced, something it had flagged in its representations. As a result, it then applied a 65% reduction, so quite a good reduction, to bring the penalties down to 11.5 million and 8.8 million respectively. So 20.3 million in total, so still above the 14 million. So the ICO considered this 20.3 million amount to still be dissuasive to other organisations and to Capita, but it also considered its pro-innovation approach, which is something that the government and John Edwards have mentioned quite regularly. This resulted in a further reduction, which also took into account the ICO's discretion to reduce the penalty on the basis of the voluntary settlement reached with Capita. And this reduction was due to the time and cost savings that the ICO made from having settled this matter early and not having to litigate it further, but also because regulatory certainty was introduced sooner, since there will be no appeal, so we know where things stand. And this resulted in the final amounts that you outlined earlier of £8 million for Capita PLC, which is the controller, and £6 million for CPSL, the processor, giving us the total of £14 million.
Wow, that took a lot of maths to get us there. Thanks for providing that helpful breakdown. But 14 million is still not an insignificant amount. With that in mind, what do you think the key takeaways are for organizations?
I'd say this case has broader implications for data controllers and processors. The decision sets a precedent for how regulators may treat large-scale breaches involving multiple entities. So it's clear they will consider fining more than one entity if group companies are involved. It also highlights the importance of internal governance, risk management, and responsiveness to alerts. Processors will not be safe from enforcement even where security measures and policies are implemented by the controller at the group level, and we have seen previous enforcement by the ICO against processors. The ICO's review of Capita's security measures also re-emphasises the importance of penetration testing, but not just carrying out the testing, but also acting on the results, because as you flagged, they had detected these vulnerabilities in 3 previous pen tests and still had not done anything. The testing alone is not sufficient to meet your security obligations under GDPR. You must act on the findings. And for larger organisations, especially those offering security services to customers, the ICO has made it clear that it will be difficult to argue that security measures are too costly or complex for you to implement. They expect a higher standard, and this will require that such organisations ensure they are adequately resourced to maintain those security measures and to respond to alerts that they generate.
So, to wrap this up, the decision is a stark reminder that cybersecurity isn't just a technical issue, it's a legal and practical one that needs to be considered at the very highest level of an organisation. So, organisations must not only detect threats, but act swiftly and decisively. Security failings carry big risks to businesses, from large fines by the ICO to class action lawsuits and reputational harm, not to mention the cost of any downtime experienced by the business. Thank you for listening today. If you found this episode useful, please feel free to share with colleagues or subscribe for more legal insights.